We weren't really happy about following Keith McCook, who we all know is an excellent procurement expert, but we have a very different vibe than he does. We have prizes, we have candy, we have bingo cards, so we're hoping that you learn and are entertained at the same time. Ellen, do you want to talk about bingo?
I'll explain the bingo. So you have a card. There's, I think, 20 different variations on the card, and these are some of the terms you're going to hear today. So this is something I use in client trainings in person. Obviously, remotely doesn't work that great. But what it is anytime you hear one of these words, you shout bingo, and we have a variety of prizes available for you. There's candy, there's little plastic dinosaurs, there's pirates because we're in New Orleans, any number of things here. I might enlist one of these fine people to distribute the prizes. There's candy here. We've got some grand prizes if you want to go for a blackout. Jessica brought this fine cap from the state of Arizona.
This is a scorpion lollipop with a real scorpion inside.
This is a white elephant undertaking.
No, but I also have a rubber chicken. Another smaller rubber chickens. These work really great in a crowd.
It's a slingshot.
Right? Yeah.
So be careful.
Anyway, this is something I use in client trainings that helps keep people engaged. It encourages people to kind of pop up, and even if they don't necessarily have a question, they can yell bingo. And then, we encourage people to select from anything they want. Also, if you're close to a bingo, you formulate a question with the term you need. That also counts. So we're not going to pause or anything for bingo opportunities or anything like that. It's just if you got one, yell out if you're comfortable with that. If not, I'm not going home with these, so trust and I won't verify, right?
All right, so we also have content.
Mostly, yeah.
We're going to talk today, take a half step back. Who are you? Why do you do what you do? And then we're going to talk about a couple of specific topics. We've got public records. We've got IT contracting. Ellen, I don't know your dog's name.
My dog's name is Ophelia. Our presentation features photos of some fuzzy bits that float around the various houses. We've also heard that helps people connect with their clients and colleagues as human beings. So, yeah, dog photos. To be fair, it was her idea, and I got a little jealous. So.
Oh, no, it's much better having multiple dogs. I think people at the state of Arizona are a little tired of seeing my dog. I brought in other dogs to kind of, even things out a little bit. But that just, goes to the point, one of the big points that we're going to have today. Oh, wait. Which is, when you're an attorney practicing in this space, it's really important to have those connections with your client and to make sure that they know you and know that they can talk to you and that you're approachable, you're building those relationships. So, do you want to do this?
Sure. So what does success look like? That's the subject here. So when you're doing government contracting, it's perhaps a little bit different than if you're coming from private sector or you've got purely private sector commercial considerations to think about in terms of what does success mean. So in the government contracting sector, no news is good news could be a sign of success. If you're not above the fold in the newspaper, that's good. If nobody knows what you do, that's good. That means you're a successful government contracting lawyer, right? Very often, nobody knows what I did, right? It just works, right? No surprises. Is everybody prepared for what they're going to do? I do a lot of IT projects. So are people able to anticipate the changes that are going to happen through the course of the project? If you've got something where you're setting up for a long-term program or a long-term usage agreement, does everybody understand how the contract works? Even if you're buying school buses, everybody prepared for what it means if there's supplies or repairs needed to the bus, right? It's more interesting than it sounds, right? Is the client prepared? Have the services launched on time? Have business process changes are understood and are they welcomed? Are emergencies and crises handled? So I can't say now, in what I do now, that staying out of the newspaper is always a good idea, because I'm the third person on the list of people who get called when there's a data breach. So you're going to hear about it. If it's being published and people are hearing about it, that's part of what we do as the response. So, but it's the success of that response and everybody understanding what role they play and what actions they need to take as part of that response. That's what success means in that context. So it can be very specific to what you're doing, right? And you got to think, short term, long term, medium term, changes in staffing, changes, any number of issues specific to the circumstances you're in.
Yeah, I like this "Who are you" slide. I use it sometimes. This is my meditative slide, the dog looking off into the distance. Particularly use this in protest trainings to remind people to calm down and that it's going to be okay. One of the frustrating things from when you're dealing with procurement officers, one of their chief frustrations is that, like Ellen said, a lot of the no news is good news. If you're hearing about the program as opposed to the procurements which led to the program, that's good news for your procurement officers. Staying out of the news, the procurement process itself staying out of the news is vital. So when things go wrong, they can sometimes be a little high-strung because, they put in all that time and effort to making sure that things run smoothly, and they don't always respond to that as well as they could. Knowing what your role is in procurement is the other side of this. So taking the half step back, what does your state organization look like? The term CPO, which Megan mentioned earlier, is used very differently in the state of Arizona than it is in many other states. Our state procurement administrators are CPO, like the chief procurement officer for the state. All of the authority runs through him, and then down to all of the agencies where we have agency chief procurement officers. So representing the state procurement office doesn't mean that you're representing all of those different agencies. So there's a lot of coordination between the staff for those different agencies, the council for those different agencies, and the council for our central procurement office. When you talk to your colleagues here, sometimes remember to take that half step back, find out what their role is in procurement, because how they answer your questions, what they're thinking about is going to vary based on their role within their organization. That centralized versus decentralized legal services, I was with the AG's office. I moved over to our central procurement office. Nancy back there is currently our senior litigation AAG within our AG's office. So we bring in our AAG for a lot of problems. Our AAG represents us when we negotiate with counsel for our suppliers or potential suppliers, but other folks have in-house doing that. So knowing what that role is going to vary a lot, and knowing that that role varies a lot from state to state is part of what you should think about when you meet your colleagues here. Yes, Keith.
Ask a question.
Yep.
One of the things I struggle with, and it's interesting because we happen to have
Use the microphone.
one of the things
You got to press the button.
One of the things I think is interesting is in today's presentation, one of you works in the AG's office. One of you used to and now works at the agency level. And I have 3 lawyers, and we're all in the central agency. But our biggest, most complex procurements are by agencies. And so one of the questions that comes up, and I really, frankly, haven't done the homework to figure it out, and I would welcome y'all's thoughts on it, is what's the relationship between the central agency? The Attorney General's office may have attorney-client privilege and work product and a relationship with every single agency, but I'm not sure my lawyers do, and is all of that stuff protected? And what is the difference?
That's 2:30, right?
Yes.
Yeah,
Oh.
Suzanne's got that covered at
Sorry.
2:30. So she was reaching for the mic, and I told her not to, because we are going to cover that, or I should say Suzanne's going to cover that later with somebody else, with Eric.
Yeah. But I think it can depend on your state and the exact circumstances, because we've got attorney-client privilege in the traditional sense, but we're also talking about working in the public context where public records laws come into it. And there can be a certain interplay between those two roles or those two privileges, if you are, exemptions from public records and the attorney-client privilege that we're going to get into a little bit here. We'll make a good faith, what's one of the things we're hitting here? A good faith effort to talk about that a little bit here in the procurement context and success in government contracting. So in contrast to what she does, I'm in general counsel. So I'm kind of general counsel for all state agencies in the executive branch. There are some sections in general counsel that are agency specific. I am subject specific. So I tootle along behind other general counsel attorneys to help them out with specific issues, or I work on some of the bigger projects. When it comes to litigation, I can also be something of a meat shield between the dispute and the trial counsel. So I will often negotiate settlements. So like if we talk about copyright violation situations or license claims or deployments, disputes about that, I'm very often the one that negotiates that settlement. But I always have trial counsel lurking in the background.
Yeah, whereas I've served as both the counsel for settlements and the client for settlements, just depending on the role that I was in at the time. But knowing what your role is also tells you what success looks like, because, is your role to figure out if a contract's going to be void? Is your role to find the best possible terms and conditions? Knowing what exactly your agency's expectations are of you is vitally important so that you know how to fit it. I thought what Ellen just said was interesting in part because you also have to understand the politics of your state and how they will affect council within your state. We have two different agency councils sections within the state of Arizona. One is over at the governor's office, and it's all of the in-house councils, and the other is my old section at the AG's office, same name. I'm not going to draw any conclusion from how that came up. I actually don't know which one came first, but sometimes there's dueling councils within your state, and making sure that you're building bridges and working together with your fellow council, regardless of what that, the authority is, the politics behind it, to get what's in the best interest of your state is also a vital part of the job. This is a big one. Are you there to provide advice or direction? Sometimes, especially when you're working with private clients or if you're in-house in a private entity, your job might be to find the best possible solution within the limits of the law. Sometimes, especially when you've got a procurement office that's doing a lot of the work in advance, and you've got folks in-house who've been working, doing the research, they put the contract together, and they have different objectives, they're just going to want you to tell you if it's legal or not so that they can move on. Do you have input on policies and procedures? Knowing whether or not where your lines are is important so that you don't overstep them. If you're expected to provide input on policy and procedures, make sure you've got the right people in the room. If you're not, make sure that you're working with the folks within your organization so that you don't inadvertently end up upsetting your client, which can definitely happen in those. We talked about negotiations a little bit, but knowing if you have different escalation processes for risk management is a big one. Sometimes there is separate counsel for risk management. Do you have input on limitations of liability, insurance provisions? And knowing what's a business decision, having that client conversation in advance so that you're on the same page about what is a business decision, what isn't, what they're going to have to figure out in-house versus what you're going to tell them, yes or no, you cannot do, is incredibly important. And that's a picture of TJ with his giant, that's my dog TJ on the left, with his giant girlfriend, Nova. They're the same age. She's got 60 pounds on him. They're very happy together.
And I would say the answer to that is both. You're giving advice, but you're also giving instruction. There's a lot of process in state procurement. And one thing I like to say is, okay, we got to understand the purpose behind the process. We're not just blindly following a process. Like, yeah, there's some things I'm going to check off to know that you've done so that the right people are making the right decision. But that's the purpose behind the specific process. I don't necessarily, there's always a time pressure on procurement. So it's a matter of helping folks accommodate the reasoning behind those steps they need to take and the reviews that need to be required, and making sure that the reviews are themselves substantive. So sometimes you end up banging some heads together until they play nice, but there's always this balance between, yes, okay, that's legal, and, well, you actually don't have the authority to make that decision. So you have to help the client understand, not be surprised by your answer is always a good sign, but sometimes you have to back up a little bit.
I put this next one up, Ellen. I was
Yeah.
curious where you typically end up in the procurement life cycle. This cycle from need over to rebid, this is something procurement offices in a lot of places take a look at. Need is, at the agency level, what do they need? How are they what's gonna be in that scope of work? And then through it, where do you typically fit in?
It depends on the, complexity of the matter. So sometimes it's identifying the need. So if we're planning a new thing, like when the state of Oregon passed its recreational marijuana law, that like 3 days after that ballot initiative passed, I was in a meeting about, okay, well, what are we going to do with this, right? So we're planning for the need, right? Procurement, we look at procurement documents as part of anticipating a legally sufficient contract. If the contract's of a certain dollar value, we, as the Attorney General, have authority over all legal matters for the state. So very often for a high value or a high risk contract, we will be directing the negotiations. Contract management is generally a client issue, but again, IT, if there's a big change order, there's questions about meeting requirements or something like that, we will sometimes come in to kind of help the client think through the situation and evaluate what their contract tools are. Hopefully, it's a matter of revisiting what we built into the contract to help manage that relationship. Sometimes we have to go back and zhuzh and adapt through an amendment or something.
Yeah. When I talk so one thing that I do on behalf of those chief procurement officers that are at the different agencies is I go in and I talk to their executive teams, and I put in a slide like this to remind them to even include procurement in that need side. So, because the agency subject matter experts will be working on something, they'll have, suppliers on the phone, and we need to talk to them about how that's inappropriate, and they need to take the step back, get their procurement team in from the beginning, start getting the cone of silence in place, get all the disclosure statements in place, all of that before that need. So some of it is even, educating your teams, educating your states sometimes on the fact that this cycle exists and that procurement needs to be involved in every stage of it, and that procurement laws are going to be implicated in every stage of it, in addition to the substantive issues that Ellen talked about.
Mm-hmm. Yeah, and it's the same context as what Keith talks about as the procurement. The contract starts at the solicitation stage. It starts at the planning stage, but your contract and anything that you can do within the context of the contract goes back to what you advertised as the opportunity, the scope of the solicitation. What did you tell the public you were going to do with their money?
And, we're going to talk about public records a little bit, but this is one place where the public records can definitely be implicated. There are public records out there that show that your agency has been talking to suppliers before that need hit the street. There's going to be an implication there that the solicitation that went out was going to be done in favor of that supplier. So making sure that they're aware of, what it looks like if it ends up on a newspaper is also vitally important. This is just a sample responsible, accountable, consultant-informed RACI chart. Going through this process, especially if you're new to an agency or new to a role, with the folks around you can be helpful. This is just one way that authority can be, or really responsibilities, the role can be defined. So knowing what in-house counsel is going to be responsible for, the procurement officer, the AG's office, if you have an associate in-house counsel, this is just one way of putting it together, where a lot of the responsibility is in the hands of the AAG for providing legal advice, obviously an in-house counsel for that, protests, knowing who's going to be responsible there, code compliance, knowing where that comes into place, all of these different areas where you really need to know who's in and who's out from a responsibility perspective, having that conversation, fleshing it out, can be really helpful. Ellen, you've got a different take than what's on here.
Right? This
Yes.
works different in Oregon. And we usually ignore it. I have one colleague who's like, the second she sees one of these, she just starts yelling. So she ignores them. It's her prerogative and her right to do so. We reserve that at all.
Okay, so that's just the Oregon approach is throw it out. Don't do this. Where, surprisingly or not, Arizona, we like to know who's supposed to do what and who's not supposed to do what. So, different states, different practices.
Yeah, in a good faith effort to get CLE credit, in Oregon we have ORS 291047, which talks about the legal sufficiency review of contracts before they're binding on the state. So some of the responsibilities between decisions and what does it mean to have a legally sufficient contract are in our rules that implement that section of our code.
Okay.
CLE credit.
Yes, important. Another picture of my dog. He's not actually wearing that tie that was drawn on. He's not that cooperative. But these are, taking that step back and knowing why you do what you do, why the rules are in place, especially when you're talking to business people who are working for agencies, people who maybe aren't just interested in following the law because the law exists, reminding them of all of these very, very in line with business. These are they're either exactly the same as the model code or they're very similar. So this is, a lot of your states are going to have something like this on the record. We pasted on the front page of our procurement code to make sure folks see it, reminding them that what we're really talking about are basic economic principles like having competition, getting as many people in as possible for when you've got offers, making sure that you've got good competition, best value for public funds. I say best value for public funds like probably 20 times when I'm talking to executive teams to remind them that the procurement code is in place so that their dollars actually go further. They follow the process, they'll get the best value, and they'll stay out of trouble.
Do you sometimes call it public monies?
I do sometimes. Well, I was going to talk about public monies in a minute, but, I do like to talk about public monies too. But, these are, we want to do kind of if you click on the similarities link in the actual presentation, it'll take you over to the NASPO content on this. But, a lot of our states are going to be very similar when it comes to some of these basic principles, whether it's competitive solicitations, having separate rules for construction, separate rules for limited value procurements. There are circumstances in which limited competition is allowed. Preferences, we have fewer preferences in Arizona than in Oregon, it sounds like. If there are additional reviews for IT procurements and if there are protests.
Yeah, so I wanted to talk specifically about their preferences, only because we've got some things coming out by executive order. Executive orders became highly used in Oregon during the pandemic because they have the force of law. So the governor can issue an executive order around, for instance, state vaccination or state employee vaccination requirements. That was an executive order that caused no small degree of excitement. But another one that's specific to procurement, because we're looking at our housing emergency, we're looking at our homelessness crisis, things that I think are pretty much on theme for many other states. We have a new executive order around homelessness, and we've got some executive orders wanting us to look at some of our contracting and making sure that it's got a very long title. It directs state agencies to take specific steps to improve equity in state procurement and contracting. So there's a citation there for it if you want to take a look at it. But we're really looking at how do we procure our contracts? Again, it's about the process and what's the purpose behind that process? What's the impact of that process? And what kind of improvements are we making? Can we make? And I think as attorneys, this goes a bit beyond just, yes, this is legally sufficient. Yes, this is a legal contract, even though it's hot garbage. This is more about, okay, this is how we're going to work together to make government work better for the people, right? So there's a role you can play. The more engaged you get with the clients in how they do things and the more insights you can provide to how the work gets done.
Yeah, and within our organization, we have separate folks who handle construction. We have separate folks who handle IT, particularly our CIO, we talk to all the time. Because when it comes to knowing what's going to happen in that additional IT review, we need to get a sense of what the timing's going to be. And we also need to know what their worries are going to be to make sure that those are in the contract to begin with, whether it's cybersecurity requirements, whether it's, just knowing what kind of data is going to be in there, and knowing how what steps to take if data issues arise. We've seen them arise in very unusual areas, from rental cars, where they were taking biometrics of state employees using those rental, and they needed the rights over those biometrics. Things like that just come up in unusual circumstances. So making sure you've got that team in place when they arise is important.
Yeah, and it's not about telling people what to do. It's helping them anticipate. There's the line from a movie about a good servant anticipates the needs, right? So you help people anticipate what they're going to see and what they need to, in the instance of a longer term contract, what they need to anticipate to get the maximum use and value out of those services or those goods, that system they're building, et cetera.
Sometimes you anticipate that people are going to be playing bingo more aggressively than they are.
Right.
And so you have a lot of
so I have a lot of
toys and things. So, these are probably just going to be up for grabs at the end of this.
I'm not going home with you.
But I'm sorry, Ellen, I think they may actually be paying attention.
Okay. Oh, and I do want to throw out a little bit about responsibility versus responsiveness. That's marked as something we're going to hit here, so we're going to make a good faith effort to incorporate it into our similarities between states. Everybody's got a responsibility determination to make as part of, when we think about it in terms of the ability to meet the obligations to fulfill the contract. I think that's how I would characterize it. Keith is nodding. That makes me feel good. Responsiveness in the context of a solicitation, I try to work with the procurement people to understand that the responsiveness depends on what you're soliciting for, but to a certain degree, did they give you what you asked for, right? Some of it's a very simple, like yes, no, check the box. Yeah, they gave you a proposal. Yes, it has words on it. Yes, it's on topic, things like that. So there are similarities there, and we hereby incorporate everything Keith says by this reference.
Yes.
Nerd joke. All right. Okay. So again, we talk about what does success look like, and it's very fact specific, right? It's very circumstances specific. We do find ourselves in a position of reiterating what the requirements are, what the law says, what the rules say, but it's helpful for people to understand why. And sometimes you just got to help people feel their frustration, right? Somebody's going to come to you with something that they've been working on for a year and a half, and then they got told, big news, now you get to do it all over again because you got to go through the procurement process. Even if that's not the intent of what was said to them, that's what they hear, right? So it's a matter of going, okay, well, let's see what we can do here. And going through why procurement's important and how it's a tool in their tool belt to make sure that public monies are being spent appropriately and that a valuable long-term usable solution can be had. So I just had a circumstance where I literally had some guy see something at a conference that a vendor did a demo on that he now wanted us to go buy for him. So we had to have a long conversation about that over several meetings because he kept going back and saying, that's what I want. Okay, great. It's not your money. You're talking about something replacing a system that's been in place for 20 years, right? You just want to go out and buy this thing that you saw at a conference. That's not the way this works. Here's why, right? Do you really want to be responsible for making that decision on your own based on something you spent an hour with? Does that sound good, right? And it's not necessarily something you're going to have a conversation with in a meeting with the procurement team. Sorry.
That's okay. As long as the conversation's happening.
It might be appropriate to have a one-on-one, right? everybody's going to know what I'm saying, but I might not necessarily say it in one meeting, right? It's about appreciating people's position and just appreciating the fact that people are human, right?
Yeah. What do we have on the next one? So this is the engage early and often. Letting them know that you are a lawyer/human, that you are approachable, that they can go to you when they have questions is incredibly important. Making sure that they, when they have ideas, you don't just say no and close your door. Saying not no, but this is how we can go about doing that, incredibly important. This one was yours too.
Okay. So, is it?
Yeah,
Oh, okay.
I thought it was.
I think I said what I said, yeah.
Great.
I said
We've
what I
got-
said.
I think either of us could probably do this whole presentation, so we're trying to put things together.
Yeah.
What's your cat's name?
That is Norton. Equal time. There's a kitty in here, and heads up. Somebody won a prize. Okay.
Oh, fantastic. Woo. All right, bingos, just come up and get your prizes. Take what you want. We got a lot of stuff. Anybody, any other bingos? Another
right.
bingo. Fantastic.
You want the rubber chicken?
Yes.
All right. First claimant of
We
the
got a
rubber
rubber
there.
chicken gone. There are toys on this table. There's candy if that's your inclination.
Decks of cards for the serious. No,
This is
I
a
believe
very
you.
adorable sticker of a cactus going to space.
Yeah. Yes. Question.
Yeah. The last thing that you were talking about, is that what you would call creating a culture of compliance with procurement, with the procurement process?
Yeah.
People who understand why they want to do what they need to do.
Okay, fabulous. Then bingo.
Yeah, no,
All right.
come up. I was doing this because I figured come up and get your bingo. Yeah, no, I actually moved from the AG's office over to in-house in part because I was tired
Went an hour
of answering the same questions over and over again, and policy wasn't part of my prior role. So we actually developed a number of policies after I came over, put together a whole library of templates and standard work documents, which are available on the State Procurement Office website, and we just got a Bronze Cronin Award for. And, you know, we've got a number of forms that we put in place in part to create that culture of compliance, including one that covers material change. Because we ask the same questions every time one of those comes through. Our state procurement administrator can actually grant material changes, but we always ask the same questions, so we put them into a form, and then we have it documented. We've got everything fleshed out in advance. I have a team that goes through and asks those fact-based questions. I mean, one thing that you'll find is this space is I started in New York where there's a lot of case law and everything. It's just a very litigious state. It's delightful. And then I went to Arizona where there's no case law on pretty much anything, and people are expected to work things out themselves. So that fact-specific, making sure that everyone's educated in how to talk to a supplier, how to be professional, how to put things in writing is incredibly important. A lot of states, you might notice, do not litigate actively. They're not going to go out and sue suppliers. You do litigate actively?
No.
Okay.
Oregon's inherently conflict avoidant.
Yeah, but a lot of states, you wouldn't guess it from Arizona, cowboys, but like really, you know, also conflict avoidant when it comes to our suppliers. People want to work together. So knowing how to get everything in writing, make sure that people are aware of the facts, vitally important. Sorry, that was a bit of a tangent.
All right, public records. In the interest of equal time, this is a pet of a different variety when it comes to working in the public sector rather than the private sector. How many people came from the private sector to public? Okay, yeah. This is a fun thing for you because you've got public records laws, you've got exemptions from disclosure, you've got the right of the public to inspect. You're going to throw up on me. You've got, in the procurement context, you've got trade secrets, and you've got, as always, when you're dealing with lawyers, the concept of attorney-client privilege. These things are all going to intersect in different ways depending on the circumstances. I think it's always, particularly if you're the one dealing with the data breaches or problems with vendor performance, you're going to want to encourage people to get you engaged as soon as possible to help secure legal advice. But generally, like, I put this up here because this is my boss's opinion on the people's right to inspect public records. This is in the policy manual. We can kind of get into some uncomfortable situations between the business transactions lawyers and the public records lawyers. The public records lawyers are in favor of disclosure at all times for all reasons. And we sometimes go, but wait a minute, no, hold on, that's maybe not the greatest idea, here's why. Sometimes we win, sometimes we lose. Generally in Oregon, if there's something that's part of a contract, that's a public record. If you've got something that's part of an offer in response to a solicitation, that's a public record, except if you've got trade secrets. Who's responsible for protecting their trade secrets? The answer is in the question. The vendor, right? It's not ours. We don't want to do it. We're not in the business of protecting private parties' interests. We're in the interest of protecting the public's rights, and we're in the interest of making sure that public funds are spent appropriately. So we're always going to respond appropriately and according to what my boss says about a public records order. If a vendor thinks their particular proposal or elements of their proposal is exempt as a trade secret, it's up to them to do it. We've got stuff in our contracts that says, okay, we'll let you know, and we're essentially going to move out of the way. Good luck. We're very cooperative here, but that's up to you. Trade secrets are a big theme. And this is different than information that's exempt from disclosure, and you've got a question. Yeah, so public records and trade secret exemptions are different than information that's exempt from disclosure as a data classification issue, right? So that's where there's some corollaries with exemptions to disclosure under public records. So social security numbers. Sensitive information that's classified as sensitive may not be disclosable or may be exempt from disclosure. Attorney-client privilege, sure, unless the public interest dictates otherwise or the privilege is waived.
Do we have a
So when you had a
question over
question,
there?
and I don't know if I was necessarily super clear about this framework, but there was a question there.
So I was just going to make a comment more than a question.
Mm-hmm.
Although I don't know if this is similar to your state. In my state, it's actually a crime for a state employee to disclose anything that is determined to be a trade secret or privileged information.
Oh.
So I'm not aware of any case law that says who decides what is or isn't a trade secret, but there's a pretty substantial penalty to state employees.
Which state is
if they
that?
accidentally disclose it. South Dakota.
Okay.
Even in accidental, there's well.
All right.
Yeah, it's a crime.
Oh,
Wow.
beware.
Don't do that in South Dakota.
Yes.
Yes, sir.
I had a
I can hear you, but I mean, it's okay.
I had a question about the, I'm from New Mexico, and the laws are very liberal in terms of the public records request. Oftentimes, if you have a vendor out there, they put the squeeze on the government to produce the information, which you don't always have. A lot of times you get a copy of a contract, and then there'll be a copy that's
Redacted?
been marked up.
Yeah.
So the question is who's responsible for producing it? I mean, it's not like New Mexico. You can't exactly step out of the way when you get public records requests like that. I mean, that's the idea, is to put the burden onto the vendor. But a lot of times the vendor is like is non-responsive? or-
Then they aren't protecting their trade secret. That's the argument that we make to them. If you want, like, we've got a request for this, you've marked this as confidential, we have that communication in writing with the supplier. This is your trade secret. Are you going to protect it, or can we disclose it? Because we're obligated to disclose it unless it's a trade secret. And we've had vendors come back and go to court and, defend their trade secret in court. And we've had vendors say, no, we didn't mean it. It says confidential on every page. It's not really confidential because it's their trade secret, and that's the decision they've made.
Meanwhile, you're getting whacked, I mean, as the agency, though, you're getting whacked at the same time because you don't have oftentimes these things come down and you're on the fly because it's the 11th hour and you're trying to put together your disclosures for whoever the requester is, and you don't have that information. And the court just says it's you, and so and then the vendor's somewhere out there. I mean, hopefully you have a responsive vendor, but not always.
Yeah, if they don't respond, then they're not protecting their trade secret is usually the way we see it. I don't know if you see it differently.
We try to get as much documentation as possible, right?
Always.
I've not had a non-responsive vendor, right? In the case where I, as legal counsel, get involved and responded to a public records request. So in a former life, I used to actually be the procurement officer, and the public records issues and the trade secret exemptions came up kind of in a high-test environment of what happens after the intent to award. So generally, as part of a proposal, we expect people to submit a copy of their redacted proposal, and I'm assuming that's a fairly standard practice.
Yeah.
And we tell them in advance, if you just mark the whole thing confidential, no, that's not.
Yeah.
We're going to come back and revisit that should somebody request your proposal. So in talking about the window of opportunity, the window of time after intent to award where you're looking at protests, that's not necessarily a public records request and a public records response question. That's more like you're giving people information they need to do in order to file a protest. So that's where the timelines and the conversations are going to get fast and quick and maybe a little bit spicy in terms of what the awardee or a higher ranked proposer might consider a trade secret.
We've got different teams on those two processes to make sure that we say, no, you talk to the communications folks, they're handling the public records process, different laws, different obligations than our protest process. Because the protest is supposed to be based on everything which is in the file that's already up on the system. It's complete according to our code. We also have a separate rule which says exactly what can and can't be found confidential within a solicitation, which we print in the solicitation, especially things like contract terms and conditions and pricing can never be confidential. We have that in our rule, which really helps.
Yeah. And Oregon has a lot of pretty good public records orders in this area. There's also some Court of Appeals opinions about it. But generally it's, okay, well, there's either real clear established, not case law, but public records order about it, so your argument isn't valid unless you sue me. Hasn't happened yet. Don't want to jinx it. But very often we usually come to a point of compromise about it, even though it takes up a very large amount of that window of time to get somebody to get their protest in.
Okay. We got about less than 15 minutes. Do you want to talk about IT contracting?
Sure. XKCD. Are we skipping over? Did you go through the...
I had the other one up there.
Okay.
Did you want to talk about what success looks like more?
Sure. Here's your introduction to IT contracting. There's no pets, although we all love them. XKCD. Generally, if you're looking for a way to make friends with the nerds in your IT shop, just find an XKCD cartoon for them. They're pretty funny. This is a classic. This is kind of old, but...
This one covers the EULA,
yeah,
which you may have in your bingo cards, EULA.
EULA, End User License Agreement. Some of those software terms and conditions everybody loves. And we got a bingo. Unless you want something sharp, I will just Here, I'll toss you a lizard and then you can trade it later. Okay, here, have a lizard.
Well,
Great.
you could take more if you want more. We got lots.
Nobody leaves the room until you take this. All right, so IT contracting. IT contracting is its own special little magical kingdom. If you want to go ahead and zip forward here. So I'd like to say it adds nuance to some of the points we hit earlier. Authority, very often you've got different levels of authority and different levels of complexity because what you're doing may probably is very likely is building a essential state service. So very often IT is the backbone of what government does. Government can't function without IT. So very often what you're building is critical infrastructure, right? This is a bridge. This is a highway. This is a data system. This is value, and it's valuable not only to government services, but to the bad guys. So there are a lot of questions you got to ask about, you know, who's doing the procurement, who's got security, oversight over security and security decisions. Risk management often has quite a bit to say. And then oversight of the whole process. If you're doing a project, even if it's just configuring a SaaS product, I just said a lot of words, it's basically configuring a preset software product for use by government rather than building something, right? Who's got oversight over that project? How many sets of terms and conditions? We're going to go, and I'll go ahead and introduce the controversy. There's so many sets of terms and conditions there. They're not in that slide, right? So you've got an end user, and I'm going to go back to this. You've got terms and conditions for the product. You've got licensing terms inherent with the code base. You've got terms of use. You maybe have cloud services agreements there. Like, where is it? Who's touching it? These are some of the questions you can ask to help figure out where all the points of agreement are. Who owns what? Do you have federal terms involved? Are you dealing with highly regulated data? Like, is the IRS going to care about what you're doing? If they do, run away quickly. Don't. But there are certain terms required for that. Excuse me.
You got it?
I got it. Also, we've got emerging issues. So again, you're very likely in IT buying something that's going to be used for the next 25 to 30 years. They want to do it in 3 months. So think about how many emerging issues you're going to need to accommodate in that contract. So like, I've got one contract on my desk. It's been in place for 20-something years. I'm on Amendment 62, I think, just because we've had to adapt and change the contract so much. It's its own little beast. I call it the Death Star. But again, it's the speed of change in government. That particular contract had to do with the Medicaid system. What happened to the Medicaid system? We had healthcare reform. We had the Reinvestment and Recovery Act. All those things impacted what goes on with the state's Medicaid system. Changes in social services affect what happens with the state's Medicaid system. A lot of federal funding comes in through healthcare and social services. The feds expect things associated with those developments.
If you have any background in construction, think about that when you hear about IT procurements. You know, unforeseen circumstances, change orders, changes to timelines, all of that.
You're the bingo.
Coming up.
Another thing is not all IT projects, not all of them are procurement. Not all contracts with IT are procurement. You've got data share agreements. You've got information going in and out with research. If you've got grants for social services to local governments, like your counties or your states, your educational service districts, those are not necessarily going to be tagged as a procurement. But they do have IT issues. They do have data share issues. And this is where, even if your focus is on procurement, there needs to be some consistency for your clients between how those agreements work. And there also needs to be risk management and how those agreements work. And that, you got to think about it as the enterprise, right? The IT people like to think about the enterprise solutions and enterprise services. When you think about IT contracts, you're really thinking about not just the government and the software it buys and the software it builds, but who else touches it? Who can create a risk for that system? So that's why you're not necessarily going to have one finite set of questions that's going to be able to answer every situation, but these are kind of the high level questions, right? So what happens when something goes wrong? How can you manage that risk? What's the response going to be? Have you reasonably? You're not going to eliminate all risk, right? With data breaches, it's not a matter of if, it's a matter of when, right? So you're not going to totally be able to protect that. You're going to be able to shift the risk of what happens when something goes wrong, mostly. So.
Would you say that IT contracting is better for someone who relates as an order Muppet or a chaos Muppet?
Yes.
Okay.
Bingo. All right. I have my boss trained now to refer to people as chaos Muppets or order Muppets, and he's really annoyed with me about it.
Yeah. Often I feel like lawyers generally are order Muppets in a chaos Muppet world, particularly in state government, but sometimes it's the other way around.
And for an explanation of what I mean when I say chaos Muppets and order Muppets, there's a Dahlia Lithwick, my Invisalign is too tight. There's a Dahlia Lithwick article from 2012 that talks about Muppet personalities of the Supreme Court justices. And it works very well for thinking about government employees, particularly government lawyers. Like, are you chaos or are you order? So we're here. We're going to be talking about these reseller agreements. A lot of my time is spent focusing on reseller agreements. I have dragged my new colleague, Suzanne, here to New Orleans. She spends a lot of time working on cloud services and reseller agreements and purchases thereunder. It's hard to capture in the slide, but this is something that was shared at the NASPO National
Annual,
Conference.
yeah.
The annual, well, it was there.
I put in too many dog pictures, so my co-presenter put in a bunch of wolves.
No, that was not me. Not this one, the other one.
Yes.
So I have challenges to this, as others might as well. It doesn't, like, this makes it read like there's 4 parties to the agreement. It's not, it's more like what I would call a turducken of contracts, right? And even then, it's not just a turducken of one set of terms and conditions. You might, like, we have an agreement with Carasoft courtesy of the state of Utah. The state of Utah is not a party to our contract.
That's very
95%
clear
of
in the
time.
MPAs,
Okay. Yeah.
like the master agreements usually.
Yeah, so we might have an agreement with Carasoft for Amazon Web Services, but we also have a separately negotiated set of terms and conditions with Amazon that were procured as an enterprise cloud platform resource. There's a best value process folks have to go through in order to purchase a cloud service. When they get to that, they might get to Amazon. They might not get to Amazon. But if they want to purchase Amazon, they can purchase through Carasoft. And I do not know off the top of my head if our agreement is with Carasoft for Amazon Web Services or we're paying through Carasoft for what we want to use our Amazon Web Services with. So you see I'm making 2 different hand gestures, right? One is a straight line. It's an agreement with the software reseller for the service, or it's we're paying for the service through the reseller, but we have that separate set of terms and conditions with the end producer.
It's good to ask questions in this area
Right?
because it can be very complicated.
And it's not like I have the answers, but I have a strategy. Right? I have tactics for what I want to do when somebody says, okay, we're going to go through this, a reseller purchase, right? And it really depends on what's the best route for the particular project in terms of who's got the agreement with who for what.
So we got 3 minutes, so I'm
We've
going to do
got 3
speed round.
minutes.
if That's
Okay.
okay. All right, so I do a bunch of presentations for state agencies, for procurement officers, for directors. There are a lot of different areas of law that you should be aware of within your state. They're going to vary. The things that we talk about, the underlying value to the procurement code, that the requirements to have competition, to not give contracts to your friends, existed well before there was a procurement code. You know, obvious stuff there. Making sure that they understand the conflicts of interest law are there for a reason. There's even case law within Arizona in the city of Eloy, an engineer took a job with the city in order to give himself and his engineering firms contracts. That sort of thing actually has happened historically in this space. That's the reason we have a code. Knowing what agency authority looks like and what's going to happen in your state if they don't have the authority to act, it's important for everybody to know. We have issues with facilities personnel, in particular, folks on the ground who are working directly with suppliers who think that they can just make changes to contracts. They can't. So making sure that folks at higher levels are aware of what is and isn't appropriate and what happens to the underlying contract if they take those actions, incredibly important. This one is an engineering case. We see this a lot in engineering contracts or in construction contracts where folks on the ground, they think they know best, so they're going to work with the supplier to make changes, and then they want the state to pay for it. Case law is saying that the state won't pay for those changes because it didn't go through the procurement office. So letting people know that there is a process there, and that if they don't follow it, the supplier's not going to get paid, the work's not going to get done, very important. Knowing how authority flows from the legislature to individuals within the procurement office and having a way to communicate that to people, very important. These are just sample slides. They'll be in the materials. This goes back to something that Keith talked about earlier. If you enter into a contract that isn't supported by allocated and appropriated funds, under the public monies law, so not even in the procurement code, over in a different title within Arizona revised statutes, you can end up with personal, joint, and several liability. Reminding people of that, it makes them more careful. And then having basic guidelines around communications with suppliers and how that interacts both with procurement issues and public records, very important. And then more dog pictures. Oops, wait, you didn't get both of the dog pictures. If you look at the materials, you will see both dogs.
And Megan gave us a present. So this is a checklist. If you, Keith mentioned, sorry, I keep reciting your name, but he said they don't hand you a checklist when you start your job. I have a checklist. I give it to people. It's here. There's printed copies of it available on the table by the water.
If you didn't get a prize but you want one, they are
You're getting
here.
one.
They're
You're not
all
leaving.
up for grabs now since we didn't have a blackout. It is 12 and Megan runs a tight ship. We will have a table later if you have more questions. Thank you, everybody.